403H. There's absolutely nothing ambiguous about it. I'll direct your attention. That's my Exhibit 11, A11. It's the very last page. And we've gone through that in great detail. And it provides that after 12 months, a conditional use approval expires automatically. And they don't even give notice to the applicant unless the applicant will apply for an occupancy permit, which Ms. Ross has testified that they did not, or before the expiration they applied for a building permit, which they did not, or within 12 months of the decision, unless the board, and only the board, extends the time period upon a written request of the applicant, which has to be received prior to its expiration. So this allows for the extension of a conditional use application if someone bothers to ask for it for only a period of 12 months. It does not allow for the resurrection of an expired conditional use approval. And Ms. Ross testified that the board didn't include anything in its decision, which is before you, that is, the board supervisors did not provide any different period of time within which it would expire. This section has further significance because if someone like Mr. Sluciak, who did not want to have a 200-foot cell tower placed right next to his property, and exercised his legal rights and did not prevail, if now that conditional use approval automatically, without even notice to the applicant, is supposed to expire, the only way that can be extended is through following the Sunshine Law, which is that the board, and only the board, has the right to extend that. But the applicant has to at least ask. They never even asked to extend it. And the board, if they were to extend, under this section, if they were to extend a conditional use approval, that would be official action. And official action takes place in public meetings. And what happened here was, for reasons that I think will try to be explained, Ms. Ross not only waited almost, well, more than about a year and a half after the conditional use had expired and granted a building permit, but in doing so, she extended the conditional use approval, which she had absolutely no authority to do. And there's no ordinance that allows her to do that either. So, the Board of Supervisors, I'm confident that neither the township nor the other parties here are going to point you to a legal authority by which the Board of Supervisors delegated the power under Section 403H to the zoning officer to just extend conditional use approvals after they've expired automatically without notice to the applicant. I don't think the applicants who all they have to do is ask for an extension get rewarded after a year and a half if they don't even ask for an extension. And what's going to happen is, so, under Pennsylvania law, there are authorities which we all have to follow. And of course, it's the Constitution, but the primary authority would be the municipality's planning code that tells municipalities what they may and may not do with regard to zoning. There's nothing in the municipality's planning code, and they won't point to anything, that allows an ordinance provision like this to be circumvented in any way. The next authority would be the case law. There is case law, and I'll share some of that with you, but all of that, there's no basis for just ignoring Section 403H here. And then there are books like these. This is just a treatise on zoning law. It's a great scholar, Robert S. Ryan. He gathers cases and he has commentary on not only what the cases are saying and what the law is. Sometimes what he does is he just offers his opinion as to what would be better law. And that's all you're going to hear tonight. So I happen to have as A13 a copy here of pages that the township is going to talk to you about tonight. But they're only going to talk about Robert Ryan's opinion. They're not going to talk about the law. Let's start with Robert Ryan's opinion. That's on the last page under Exhibit A1-3. This is what they're going to talk about. Okay. Actually, it's under 189. Okay. Comment on the effective appeals. It has generally been thought that the common ordinance provision, so this provision 403H is very common in almost every municipality in the Commonwealth of Pennsylvania that has zoning ordinance. It's generally thought that the common ordinance provision that provides for the expiration of a special exception or a variance, or you could say conditional use, does not begin to run until litigation connected with the variance or special exception is finally concluded. This is best illustrated by the fact that although this issue arises dozens of times a year in Pennsylvania, no case holds that the failure of an applicant to seek a permit or build during the pendency of litigation voids his approval. So he doesn't cite any cases. He just says, well, I think this is true because I haven't found any cases on the point. And so this is just his opinion. And I'll tell you what, I think Robert Ryan has a good idea. And probably Cecil Township one day ought to amend their ordinance that says that if a person gets conditional use approval, and then there's litigation that follows, that the time period doesn't begin to run until after the litigation is concluded. But that's not what it says. It doesn't say that. The Board of Supervisors have not made that change. And this isn't the first time this issue has come up in Cecil Township. The Board of Supervisors, have decided to leave that language as it is. Now, if we go back to 186, here are some actual cases that have been decided. So the first one I'm going to refer to is in section 9.4.30. It says, the Commonwealth Court has indicated that a zoning ordinance may provide for the expiration of a variance, could be conditional use, if a building or use permit is not obtained within a specified period of time. In that case, it was 6 months. Most ordinances contain such provisions, and there is no reason to believe that reasonable limitations of the sort are invalid. That's also his opinion. There's no reason to believe that these limitations on how long you can sit around on a conditional use application and not build and not even ask for an extension, there's no reason to believe that those aren't invalid. That's not the only case. We turn to 187. In this Lucia versus Zoning Hearing Board of Upper St. Clair, the owner obtained a conditional use permit authorizing construction of a nursery subject to the condition that if the work didn't begin in 6 months, said permit will expire and be canceled by the zoning administrator, and written notice thereof shall be given to the persons affected. More than a year later, the owner sought an extension of the permit, urging in part that the permit had not expired since the administrator hadn't given him notice. The court held that the permit expired automatically under the expiration of 6 months, and while the failure to give the notice could create an estoppel issue, if there had been reliance on the failure, it did not prevent the automatic expiration of the permit. And it said here, something that this board would want to take particular note of, the opinion indicates that the board lacked the power to grant an extension of the permit after it had expired. And says, sure, the owner can go get a new approval. Well, there's a third one, the Pyle case, Penn Hills. It's a 1986 case. The owner obtained a conditional use approval by the action of the Court of Common Pleas. A little less than a year later, the municipality enacted a provision requiring that a conditional use be completed within 2 years of the date of approval. So what they did was they applied the limitation from the date of the enactment of the ordinance So the owner actually had 3 years. But the owner didn't apply for a building permit until an additional 3 years had passed. The Commonwealth Court held that a municipality may amend its ordinance to impose a reasonable time limitation which runs from the day of the amendment as to prior approvals. And that's what Cecil Township has done with good reason. But there aren't any cases. It's just a good idea. If a municipality wants to, and they don't have to, maybe it's a good idea to give someone who has a conditional use approval, give them a break if there's litigation. But your Cecil Township Board of Supervisors have elected not to do that. And so when Crown Castle approached Ms. Ross and asked for a building permit, their conditional use approval had expired more than a year before. But they got the permit anyway, and that's just very wrong. It's not fair to Mr. Sluciak. It didn't happen in a meeting, in a board meeting, and Ms. Ross didn't have the power to extend that, thus making the issuance of the permit appropriate. And then finally, to the extent that the township or anybody else is relying upon, this learned treatise that doesn't actually involve cases, what they're doing is they're attacking the validity of the ordinance. They're saying we don't like what it says. They may be saying how unfair a provision of that is. But they have not filed a challenge to the validity of the ordinance. So they can't collaterally attack the ordinance by persuading you that it would be unfair. Maybe it is unfair. Lots of ordinances are unfair. This one could probably be improved, but that's the state of the law today. So for that reason, we're asking this board to find that because Crown Castle's conditional use approval had long since expired before Ms. Ross granted the building permit, that she had no right to grant that building permit. She had no right to extend the conditional use approval. Thank you very much.